have authority outside of here,
Right.
or if it's the president or the chair of the board, or is there something else? Is there anything else that that person or body needs to be mindful of outside of the board meeting?
A couple things. So if the threat just happens, just someone sort of mouthing off to you and says, "I'm going to sue you, bastards," excuse my language, I apologize. "I'm going to sue you," but there's nothing to back it up, but there's no letter from a lawyer, there's no claim that's been filed, then you don't necessarily have to do anything about that, because who knows whether the threat is credible, right? If it happens in a public meeting, it's different. It would give you a justification. But it's a case-by-case basis. How credible is that threat? So. Okay, and then here are the other items that can be discussed in closed session. Real estate negotiations. The real estate negotiations exceptions sometimes can be tricky, and there are some public agencies in the past that have been accused of sort of abusing that exception. Really what the law says is you can meet with your designated negotiator, whom you have to name on the agenda or before you convene into closed session. But you're allowed to talk about the price in terms of payment for that real property, whether you're buying or selling. You're not necessarily allowed to talk about what development might happen at that property or other things relating to the property unless they relate to your price in terms of payment. So I always tell my staff, look, either you've got an appraisal or you're ready to talk an appraisal, or you're ready to talk about things that are going to affect the price in terms of what that real property transaction might ultimately be.
This is a sort of a hybrid remark or question, but I've been frustrated in trying to do real estate things in closed sections because of how limited what it is that you're allowed to talk about. And some of it's Brown Act stuff, but others of it is just the way you sell property and the rules for the selling property. I feel like you can't make good decisions limited to the narrow things that you're allowed to talk about, but I think that's a question for the legislature, not the.
I think that's exactly right. I mean, I couldn't put any better, and I've shared your frustration at times. 54957.6 is the closed session exemption for public employment and labor negotiations. So whether you're talking about hiring or firing or disciplining or demoting employees, those are allowed in closed session for the purpose of protecting the employee's confidentiality, right? Our personnel facts are personal to us and deserve a certain amount of confidentiality. Labor negotiations, I think that's pretty clear as to why that requires confidentiality. You don't want to harm the agency's position in its active and ongoing negotiations with your labor unions that you're interacting with. What does somebody call them? Your bargaining partners. And those are very real business-like concerns. Closed session to discuss issues of public security. So you want to make sure that if there are threats against your facilities or threats against your staff, that whoever is making those threats doesn't have the ability to listen to your conversations about how you're going to protect yourself from those threats. At the end of the closed session, you're required to reconvene into open session. You're required to report actions that have been taken, and the statute lists specific actions that must be reported out. And sometimes there's confusion about this because sometimes in closed session, the body will give direction to staff to take a next step on something or to take another action related to what the closed session was about that may or may not be a reportable action. And really the only answer I can tell you for that one is have your lawyer check the statute to make sure that the decision that you're going to make or that you've made needs to be reported or not. An example of when something that you approve is not necessarily reportable is, let's say you're approving a settlement agreement in closed session, but the other party hasn't yet approved the settlement agreement, but you've taken the vote to approve it. It's not reportable until they actually approve it and sign it. And then it would become a public record.
Hey, Ruben, can you go back
Sure.
to the previous slide? So what, when it comes to, like, let's say, a CEO's evaluation, can salary be, is that inclusive of discussing salary in the closed session, or is that not permissible?
So the general rule is that it's impermissible with one exception. If you're going to adjust an employee's salary downward as a result of taking action to discipline them or demote them, then this discussion can take part of the closed session in that context. But you can't meet in closed session to set the salary for any of your employees.
Can you have a discussion about it?
Nope.
Okay, so that has to be done. So it has to be agendized on an open session item
It does.
and discussed publicly,
Discussed publicly, and
voted on publicly.
new law went into effect I think it was adopted in 13, went into effect in 2014, which says you can't set salaries for certain high-level executives, so your superintendent, there may be one or two other positions for school districts, I can't remember quite frankly. You can't set those at a special meeting, it has to be done at a regular meeting in public.
Okay, and then so when you're voting, because it seems like part of it is closed session, like the reasons behind like a performance evaluation. Obviously, you can't discuss that, or can you? I mean, there's a reason why it's closed session.
In the closed session?
Right, in the closed session you can, but like let's say you're voting, can you? Is there what can you say? What can and what is not allowed to look for the way you're voting?
If you're
a certain
voting
way.
on what type of
Be
item?
aware, we're about ready to go into a closed session regarding
I
this.
think I saw that. I think I saw
Yeah,
that.
and we
that
have
headline, yes.
agenda items on litigation regarding the same matter.
Okay, so
I'm
and
not
sure
talking-
I understand the question. quite
Excuse me a
frankly.
second. Yeah, I'm not talking about that. I'm just talking about like taking a vote on like let's say a salary adjustment or a increase or subsequent to an evaluation. When we're taking the vote publicly, is there something that we need to be like? We can't say certain things that is in the confines of closed
So
session.
yeah, so my advice is always to protect the confidentiality of the closed session. Even though certain votes have to happen in open session, it is impermissible to rehab that discussion in the open session.
But what can you say in order to, let's say, look, this is the way I'm
So
voting or not voting or what have you?
So if you're taking an action to adjust someone's salary in an open session,
Mm-hmm.
let's just say you're going to give them a raise, you could say, we had a performance evaluation in closed session. As a result of that, this item is now before us to amend the contract to give the raise. Same thing could be said for the other way around, right? You could make reference to the fact that you had a closed session, but not discuss any of the details of what was happening in closed session or what was discussed in closed session.
Right. That's not what I'm referring to. What I'm referring to is, can you disclose why you're voting a certain way, the reason behind your vote?
Not if the reasons behind your vote
Outside
were
of the
only
closed
known
session.
in closed session.
I gotcha. Okay.
So if
Perfect.
that's where that information came from, that's where it stays.
Okay.
It's not required, but if you wanted to, you could appoint the clerk or secretary or somebody else, an employee, another board member, your attorney, to keep records of closed session. They call it a minute book. I've had clients who've had me do this in the past where I have a form that I just list what the item was. I don't really give any details of the discussion necessarily, but I take the vote of each member and I keep that file in my office so that it's available for my review or the board's review if they ever want to bring it back up and recollect it. If there is a minute book kept, it's not a public record, not only because I would keep it as a lawyer, but if your clerk kept it in her files, it would still be a confidential, non-public record. So if you have a public meeting and not all of you show up, what happens is any of you that are actually there can adjourn to another time. Usually it's going to be your next regular meeting. If nobody shows up at all, usually the clerk is here, and she will adjourn to the next regular meeting. We talked about teleconferencing a little bit. How am I doing on time?
Yeah, I was just going to tell you, Ruben, it's a quarter to, you have 15 minutes. I know you looked at your phone at one time thinking that you were looking at your watch.
Yeah.
But 15 minutes.
Okay. Is there something that the board wants me to focus on for these last 15 minutes, given sort of, where questions that you had, things that we haven't discussed yet?
Closed session,
Uh-huh.
but when they report out, we have to call the roll call vote on that?
That's right.
And
That's right. There should be I thought I had a slide that says the law was just changed, that the vote and or abstention of every person that voted in closed session must be reported out.
I want to make sure you referred that to closed session also.
Yeah.
Isn't aren't all votes now roll call votes? Closed
Roll
and
call
open?
votes in closed session?
No, and in open session as well.
That's not my understanding. No, I could be wrong, but I don't think I've heard that's a pretty broad rule. Every vote?
I think it is written a little different, but it was at the suggestion of our attorney to make them all roll call votes, so we do.
Certain items have to be roll call vote, but for example, your consent calendar, I don't think it's a roll call vote.
We've gone both ways, and now we're just doing roll call.
Yeah, which is acceptable. I'm not, if I missed it, I apologize, but I wasn't aware that the law changed that way.
We were told that by our clerk.
Yeah, I mean, I've been at meetings in the past 2 weeks where certain items were roll call and certain were not.
That's why I did ask the question to the members of the board too, if they had questions specifically, and I know I put some in. And I also was going to give you an opportunity to give almost a disclaimer, because as I'm listening to questions, I caution everybody here, whether you're here or you're not here, is that you are giving a general presentation on Brown Act, and when I'm listening to questions, knowing we have items that this is, please do not connect the dots and say, well, Ruben said according to this, this, and this. Therefore, every time in Brown Act, that's why you have legal counsel on a specific item. But I will give you the question I had is really something because with technology as it is today, with our closed session, do you have much on closed session with, in particular, so many people now text in closed session? Is there rules regarding the texting, or is that again just a policy of the individual board?
So the courts haven't yet caught up with technology when it comes to specifically closed sessions and texting or emailing. There's no statute that's addressed it, and I believe no court decisions have come down one way or the other. For example, can you not have your phone out during a closed session meeting? I have been counsel to boards that have adopted a rule that say all of us are going to keep our cell phones in our bags and not have them out during meetings. I will tell you that the reason for that was that there was some concern that folks were recording meetings illegally, or letting someone else listen in. This long time ago in a country far away, in a different place. But there's no set statute about it, and there are no reported decisions to my knowledge.
What about research? You're talking about something in closed session, and they say, well, I think this other group just negotiated a contract, and they got this, and the guy goes, I'll Google that. And
Interesting. So, I mean, from my perspective, to the extent that that's helpful for a body, I would consider allowing it because there's no rule against it, right? It's certainly information that's available to anybody. If you can Google it, it's publicly available. The question is whether you allow that to happen during your closed session meeting. It can be disruptive.
And it doesn't mean it's true either. But
Oh, no. Well, anything you get in writing, trust but verify.
Long ago. The other question, this happened when I was on the Long Beach City Council a long time ago, so there's been many changes, obviously. And that was in closed session items, communication, and it was back then, and this is a little bit of a hypothetical, but nonetheless, it was real. Has it changed? And that is communications with individuals on closed session items. In this particular case, and the reason I'm bringing it up because it can be very real, and that is the individual, there was a member of the board then communicating with the individual that had a lawsuit with the city.
Oh, yeah.
At the time, the results were that the council member was publicly,
Admonished.
yes.
Yeah.
Is that still, or is that becoming, my point is, I think it's becoming even more serious today.
Well, I don't know if it's more serious, but I know that it's serious. This notion of the sacrosanctness of a closed session, some people just quite frankly have a challenge with it, which it doesn't compute to me, quite frankly, because it's very clear to me as a lawyer that there are specific reasons to have closed sessions, and it's always about protecting the public agency's interests, right, and protecting the confidentiality of your employees or your whoever is the topic of the conversation. So the Brown Act specifically says that it's against the law to divulge information learned in a closed session without the permission of the board, okay? And, the penalties that could attach to it vary. If it's an employee that you find out that release closed session information without permission, you can discipline them or fire them. The Brown Act specifically says that. If it's a member of the board who did it or who you think did it, they can be reported to the grand jury, and the grand jury can conduct an investigation and decide whether to file civil charges. I mean, it's taken seriously enough that, you know, the law specifically recognizes the grand jury protection or remedy and the firing remedy for employees. Yeah, and do you remember I started very early about this thing about collecting information that's given in writing at the closed session? You know, and the reason for that, and I had it happen to me once, I prepared a closed session memo for a body that I was advising, and within 3 hours of the adjournment of that meeting, that memo was up on someone's blog. And it's extremely unfortunate and challenging. As a lawyer, but also as professionals, sort of doing what we need to do our jobs correctly within the confines of the law. And in that situation, it was really to the detriment of the public agency. And you know, that whoever released it is going to have their own issues ultimately. But I take that very seriously.
So I'm sorry, who investigates that, or how does one?
So the statute says you can make a report to the grand jury, to the civil grand jury of the county in which you sit. You could probably call the DA if you wanted to. The DA's Public Integrity Division takes these issues very seriously as well. And you know, if it's an employee issue, if it's a disciplinary issue, you report it to the superintendent. Got about 10 minutes. Any other specific questions? Thank you very much for your patience. I know this stuff is dry and sometimes repetitive.
Interesting. So I guess the challenge is, and you just mentioned this, that our responsibility, of course, is to the organization. But as elected officials, we also have a responsibility to our constituency. So what advice do you give in terms of that fine line, particularly as it deals with closed session matters? And, you know, how do we balance that so that we are not in violation? As you said, we have to comport ourselves within, you know.
Sure. I mean, I appreciate where the question's coming from, and I've gone through clients as they struggle with these sort of different, these different allegiances pulling in their direction, right? Because you're right, you do have constituents who are pressing you for information. Mm-hmm. I think when it comes to closed session, it's actually not a fine line. I think it's a bright line, and with all due respect. That's and the bright line is, if there's an item that qualifies for a closed session consideration, you absolutely have to give it the confidentiality and the respect that it deserves, with the following caveat. If the board has made a decision collectively that you are willing to forego that confidentiality and that protection for whatever reason, maybe there's a public policy reason, maybe there's a litigation reason, maybe there's a political reason, it's not my job to make your decisions, quite frankly. It's my job to tell you what the law says you can and cannot do. The law says you can choose to abrogate the closed session confidentiality. You can choose to disclose information that would otherwise be confidential, but it requires affirmative action by a majority of you at least. So, does that answer the question?
Mm-hmm. Ruben, I have a question about this use of email, private email. What exactly is private? What exactly is characterized as public?
Sure.
You know, we're all community members. Some people use their work email. I use my personal email. I don't use the district's email. How I know there's the Supreme Court is looking at the San Jose case. So, what is, if we get like a public records request requesting board members' emails, while the review is going on, what do we do? What are some of the things that we're obliged to do or should do?
Very, very hot topic right now. So I don't know if the rest of the board is aware of the San Jose case that Trustee Zia just referenced, but essentially there was a case that came down from, I believe it was the 4th District Court of Appeal, a case in San Jose where a Public Records Act request was made of texts and other email messages that board members had sent and received on their personal devices. So they're, their own PDAs that they pay for with their own money, I believe was the factual situation. You also noted that the Supreme Court has taken the case. So the decision at the Court of Appeal was that if it was a private device, it was non-public, okay? And that the public agency did not have the obligation to basically reach into my pocket as a board member and ask for my phone so that they could search through my texts and my emails to see if I had documents that were responsive to the request. That was what the court said. The Supreme Court has said, hey, we're going to take a look at that rule. We're not sure if we agree. And so the status of the law is a little bit up in the air. It's unsure. The best advice that I give clients is and we're talking Public Records Act here now. It's not a Brown Act question, truthfully. But I'm happy to give the answer if that's okay, Mr. President, because it's an important issue. I believe the law requires that if the public agency provides your cell phone or your device or pays any part of the bill, that texts and emails that are on that device discussing public business are probably public records, because public agency resources have gone into facilitating that communication, right? The general rule under the Brown Act is that any document that's created, stored, or owned by a public agency is generally going to be a public record unless an exemption applies. So emails sent from your district email address are going to be public records if they deal with public business.
So let's say we hypothetically get a complaint that there was a Brown Act violation and there was a request for correspondence that happened between board members that happened on their private emails. Is that something that has to be shared? Doesn't sound like it does. Or let's say one member is a public employee elsewhere. How does that play into it?
That's a very good question.
Well, two members,
It's very,
hypothetically.
So again, I mean, these are very specific questions, and I don't want to necessarily give an answer that's going to be taken for the gospel. But I'm telling you, in general, an email that goes to another public official, to a member of the board goes through let's just say they're a city employee, and it goes to their city email address. So that email is being stored on the city servers. So technically, it is the city's public record, arguably, potentially. I mean, it's not 100% clear under the way the law is written right now. Because the other issue you have is, well, is it really a public record for the city if it's not dealing with city business but dealing with school district business? So those issues, unfortunately, they're not clear answers. There aren't clear answers yet.
We've heard sometimes that there's such things as one-way communications. What's that?
So I alluded to this a little bit earlier where the Brown Act allows individual communications, so it's not a violation for any member of the public to come up to you and to talk to you individually. The Brown Act also doesn't prohibit you talking to an individual board member about an issue that's coming up, as long as you're not involving a majority of the board. Right? So this concept of one-way communications and the example I gave was the City of Palmdale case, where it was the memo from the city attorney to the entire board. The board didn't necessarily ask for that communication. They received it as passive recipients. They weren't communicating among themselves through that document necessarily. So the court said it's not a meeting. It's not a violation of the Brown Act. Now, it's a little bit different if in that one-way communication, I say, as your counsel, board members A, B, and C told me and believe that item X should be voted down at your next meeting. Well, then I facilitated a Brown Act violation, right? Because I'm divulging the thoughts and opinions of a majority of the board towards trying to achieve a collective concurrence, which is the legal standard of the Brown Act, okay? Any device that's going to try and achieve a collective concurrence, or any device that's going to allow more than a majority of the board to hear, discuss, or deliberate an item on your subject matter jurisdiction outside of a public meeting is potentially a Brown Act violation.
And not just on substantive issues, but the way business would be conducted at a meeting as well?
Well, so the question there is the way business is conducted at a meeting part of your jurisdiction? Is it within your purview? I think the answer is yes. right? Because the board has the ability to adopt policies and procedures as to how your meetings are run, for example. You know, again, they're tricky questions, but if I'm going to be offering advice, I'm going to err on the side of caution, not to engage in that kind of activity, because even if it's not a Brown Act violation, at least you haven't put yourself in the position of being accused of trying to violate the Brown Act. It's one of those things where an ounce of prevention is worth a pound of cure. The law is sometimes not 100% clear.
So this is a really great question because I've also heard this concept of one-way communication. It was brought in the community college league conference that we had, and it was considered allowable as long as not everybody replies all and it becomes this mess. But like, for example, like Trustee Otto last year, like July, when we were, before we were going to go through an appointment process for Trustee Archuleta, sent out an information saying, look, this is what the CCLC guidelines are on appointing a person. So just thought you guys should know, and sent it to the entire board. I mean, that's just like information. Would that be considered, because it's on the, here, we know we're gonna go through this, it's gonna be on the agenda, here's an information. Is that considered a violation, even though like it wasn't trying to build a consensus or deliberate or influence decisions, just an information? This is what other like our associations in the state or nationally use.
So that's where you get to this concept of the people who received that communication were passive recipients, and did they or did it or did it not, or did it or did it not lead to hearing, deliberating, or discussing an item within their subject matter jurisdiction? I don't know that the law is 100% clear, and you're putting me in a little bit of an awkward position because I don't want to play referee on Trustee Otto, all due respect, sir, or anybody in particular. But I will tell you that if that were challenged, I believe in a court of law, what the court's going to look at is, okay, what is the information that was pushed out to the body, through what vehicle, what was the intention of the person who sent it, and then what happened after they received it? Did it facilitate a Brown Act violation? Because then it could be seen as the beginning of a chain of events where ultimately the public was deprived potentially of the benefit of listening to or watching the board make a decision or hear information that would lead to their decision. But it's not clear cut,
Right.
But if it's sent out early as information as to ways that these things are done, and it's not directed at anything in particular or any particular decision-making.
Again, like I said, you'd have to look at the content of the communication.
And the intentions.
All right.
Yeah.
All right, Ruben, thank you very much. We are, by the way, for the trustees, the Excellent in Trusteeship Program, this actually be used for credits towards that certificate for your Brown Act training, even though I know you've taken Brown Act training at the league, from the statewide and from the national. So Ruben, thank you very much for your time on this item, and you can see if I'm following everything. Again, for people that may have come through, this was, again, because from the March 24, 2015 board meeting, the Board of Trustees recommended that the board schedule an open meeting to receive training on the Brown Act, and that's what this was about. So thank you.